Breaking news. Welcome to today's headlines. How Attorney General Malami manipulated court over rulings on Electoral Act. How Attorney General Malami manipulated court over rulings on Electoral Act, says Falana. To my dear listeners, now I welcome you to today's news. Please stay tuned as I read today's news. Mr. Falana said the AGF, despite being a defendant in all the cases, did not draw the attention of both Ibadan and Umuahia divisions of the Federal High Court to the Abuja divisions restraining order concerning Section 84(12) of the Electoral Act. Human rights lawyer Femi Falana on Sunday accused the Attorney General of the Federation and Minister of Justice Abubakar Malami of manipulating the Federal High Court into issuing conflicting decisions on Section 84(12) of the new Electoral Act 2022. Mr. Falana said Mr. Malami pretended not to be aware of the restraining order of the Federal High Court in Abuja, barring him and others from tampering with the legal provision, but vowed to implement that of the Umuahia division of the court, which ordered the deletion of the clause from the law. The senior advocate of Nigeria, in a statement providing some details of the decisions of 3 divisions of the Federal High Court on the matter, blamed Mr. Malami for allegedly manipulating the court into issuing the conflicting orders. He said Mr. Malami cannot, therefore, pick and choose which of the orders to obey or disobey. It is right that the Attorney General cannot choose and pick the orders of court to obey or disobey. More so, when it is undoubtedly clear that the Attorney General deliberately set out to manipulate the Federal High Court to issue conflicting orders in a desperate move to annul Section 84(12) of the Electoral Act, Mr. Falana said. The division of the Federal Court in Umuahia, Abia State, had, on March 18, nullified Section 84(12) of the Electoral Act, a decision that sits well with President Muhammadu Buhari's earlier protest against the controversial legal provision. The novel statutory provision had prohibited political appointees from voting as delegates in party conventions or Congress for the election or nomination of candidates. In a verdict, the judge, Evelyn Anyadeke, held that the section was unconstitutional, invalid, illegal, null, void, and of no effect whatsoever, and ordered the AGF, who was the sole defendant in the suit, to forthwith delete the said subsection 12 of Section 84 from the body of the Electoral Act 2022. She anchored her decision on the ground that the provision conflicted with the constitutional provision that already gives political appointees who intend to contest in an election to resign at least 30 days to the election. Many lawyers have faulted this reasoning, arguing that political appointees are not part of the category of persons required by the Constitution to resign at least 30 days to the election. Mr. Malami was picked as the sole defendant in the suit, filed by Unduka Edede, a member of the Action Alliance (AA), a fringe political party in Nigeria. The AGF has shown extraordinary interest in ensuring the striking down of the Section 84(12) of the Electoral Act, which would have forced him out of office early to realize what is believed to be his ambition to contest the 2023 governorship election in Kebbi State, his home state. Malami engaged in forum shopping, but chronicling two previous rulings of the Federal High Court in Abuja and Ibadan, Oyo State, on the same matter. Mr. Falana, a senior advocate of Nigeria's Son, said Mr. Malami desecrated the office of the AGF by engaging in forum shopping to get a favorable verdict. No doubt, this is the first time in the entire history of Nigeria that the office of the Attorney General of the Federation has engaged in forum shopping for favorable orders of the Federal High Court or any other court. It is high time the dangerous manipulation of the Federal High Court was stopped as the nation prepares of the 2023 general elections. A statement issued on Sunday by Mr. Falana read. The human rights lawyer pointed out that while the Abuja court barred Mr. Buhari, the AGF and the National Assembly from tampering with the newly amended Electoral Act, the Ibadan Division of the Federal Court declined jurisdiction on the matter. On March 8, 2022, Inyang Ekuo, the judge, had in a ruling on an ex parte application by the opposition People's Democratic Party (PDP) held that the amended Electoral Act, having become a valid law, must not be unduly tampered with. Specifically, the court restrained President Buhari, the AGF and the National Assembly and other defendants in the suit from removing Section 84(12) of the Electoral Act or prevent it from being implemented for the purpose of the 2023 general elections. To my dear listeners, now we've come to the end of our today's news. Please do drop by at the comment section and let's know what your view is all about. Thank you for listening.